Panalo ang Pilipinas. Panalo. Panalo ang Pilipinas sa arbitration case laban sa China.
Ladies and gentlemen, good morning, and welcome to the National Symposium on the Law of the Sea and the West Philippine Sea.
To begin with, may we invite everyone to please rise for the singing of the Philippine National Anthem.
kayang magiliw, perlas ng silanganan, hanap ng puso, sa dibdib mo'y buhay.
Panghinihang, duyan ka ng magiting.
Sa manlulupi, di ka masisingil.
Sa dagat ang tulog, sa simoy at sa langit mong lugaw. May dilag ang tula at awit sa paglayang minamahal.
Ang islap ng watawat mo'y tagumpay na nagniningning.
Ang bituin at araw na kailan pa may di magdidilim.
Ang mamatay ng dahil sa'yo.
You may now be seated. Before we proceed, PS, in collaboration with the for Security Cooperation in the Asia Pacific, University of Asia and Pacific Law School, University of the Philippines Law School, Institute for Maritime Affairs and Law of the Sea, ABS-CBN News, One News PH, Philippine Information Agency, West Philippine Sea Transparency Group, and the Philippine Coast Guard.
The National Symposium on the Law of the Sea in the West Philippine Sea is just the first of the series of events in commemoration of the 10th anniversary of the Arbitral Award. To start with, may we request Professor J. Batong Bakal for the agenda setting.
Good morning. Good morning. Could we just have I just have a few slides for the agenda setting. First of all, let me thank the WPS Foundation for having organized this event. This is indeed quite an important event in commemoration of the 2016 Arbitral Award. It's only the first of a series of activities that we know will be taking place within the country within this year. So my task this morning is to set the agenda, but I find it a little bit difficult to set the agenda given that you already had a very cinematic preview just now. So in terms of the actual schedule of activities, the actual agenda for our activities over the next 2 days, as you know, this is a symposium on the law of the sea and the West Philippine Sea. So we will be discussing, first of all, the United Nations Convention on the Law of the Sea. There will be a full educational discussion of all its various features, and we hope that there will be enough time as well in each session for what I'm sure will be many questions and answers, given that this is such an important document, and our country, as you know, relies very much on the sea as being a maritime and archipelagic nation. Okay, can I just ask the presentation slides to be presented for this morning? Teki natin. Okay, so the Philippines, as you know, is a maritime and archipelagic nation, and we have been celebrating this every September of the year. But what does it actually mean? No? Now, to be a maritime and archipelagic nation is to imbibe basically what we would call an archipelagic perspective and archipelagic philosophy. But this archipelagic perspective philosophy is only now beginning to sort of gel together and really be spread. Okay? Next slide, please. First of all, let me begin by looking at the land aspect, no? The land component of our archipelago. Many people actually begin with the land, but in our archipelago, one important feature that is not present in many cases is the fact that our islands, our archipelagic nation has actually evolved. It is actually comprised of several components that integrated into our nation at different points in time and on different legal bases. Okay? So we're all familiar with the Treaty of Paris. Every lawyer, I assume, will have come across it at some point. But unfortunately, one thing that we have noticed is that in most law curricula and most discussions, it stops there. Meaning that there is no further and deeper examination of what it is that is meant by the Treaty of Paris. But when you look at the history of our nation and the legal instruments which basically document the basis of our nation's evolution, you'll find that the Treaty of Paris is only the beginning of what emerged as the Philippine Archipelago. The Philippines, after all, under Spain was known as the Philippine Islands. It turned into, Islas Filipinas, which turned into the Philippine Islands under the Americans. And this group of islands was originally described not in terms of a list of each and every one of more than 7,000 islands, but simply as the group of islands that lay within a particular area. And that area was defined by the box, the irregular box drawn by the Treaty of Paris. Okay? But now, in addition to those islands that were inside this box, the Treaty of Paris, there came a need to sort of amend it a bit, or to clarify rather, that it was not just the islands in the box, but also some islands that were outside of the box, but were under Spanish sovereignty or claim of sovereignty. And that is where the Treaty of Washington came in 2 years later. To basically clarify that even though the Treaty of Paris refers to islands within that irregular box, it also included the cession of islands outside of the box as if they were inside the box, as long as they were under Spanish sovereignty or claim of sovereignty. Okay. Now, in addition to these areas, everybody will also have had a passing familiarity with the Philippines' claim to a portion of North Borneo, often referred to as Sabah, but actually not exactly covering the entirety of Sabah. And this one is not based on the Treaty of Paris or Treaty of Washington cessions between Spain and the United States. This is based on a document, in an agreement signed between the Sultanate of Sulu and Baron de Overbeck, okay, and Alfred Dent. Back in 1878, it actually predates the Treaty of Paris, but that document is made the basis of a claim announced by the Philippines in 1962, okay, decades after the formation of the Philippines as a republic. Now, in addition to that, you have Bao de Masinloc or Scarborough Shoal, which actually was subject to exercises of Spanish and American jurisdiction, as well as Philippine jurisdiction especially after the Commonwealth period and after the Second World War. Now, notably, with respect to Bao de Masinloc or Scarborough Shoal, there is clear evidence of the exercises of such jurisdiction and even an express recognition that the Philippines could take sovereignty over the shoal by the United States. Okay? The recognition by the United States that the Philippines, then under the Commonwealth government, could take sovereignty over the shoal, and expressing no objection thereto. And then last, of course, is the Calayan Island Group, in the southern part of the West Philippine Sea. This one is subject is subject to Philippine sovereignty, not on the basis of the Treaty of Paris, but rather through our occupation and administration of those islands later on. So you have at least four different components of the archipelago, becoming part of the Republic of the Philippines at different points in time on different legal bases. Next slide, please. Okay. So the fact that the archipelago is comprised of different components, that it evolved over time, that it basically grew, expanded, is something that is not often discussed, even in our law schools. And this is what often gives rise to confusion about exactly what the Philippines is comprised of. Okay? But that is just the land. Okay? Again, next slide. The acquisition of territory is based on customary international law. The laws that determine the validity or invalidity of that sovereignty, the existence of that sovereignty is based on customary international law, which is largely unwritten, largely. Okay? When it comes to the sea around the islands of the archipelago, a different body of law applies, and that is the law of the sea, which has been mostly codified now into the United Nations Convention on the Law of the Sea. Pakiclick lang. Okay? And the UN Convention on the Law of the Sea establishes entitlements to the maritime areas around each and every one of these islands, and in the case of the Philippines, around the archipelago, based on the rules that are now enshrined in the convention. Okay? This is what enables us to lay claim to sovereignty over all our inter-island waters, as archipelagic waters and internal waters, territorial sea of 12 nautical miles around it, no? And then an exclusive economic zone and continental shelf, which to which we have sovereign rights to all the natural resources in that area. Again, notice, this is a different body of law, different rules apply to the sea and its resources than those that apply to land. And that is what we will try to emphasize in the course of the 2 days, what these different rules are and how they apply to the waters around our archipelago. Next slide. This is very important because if you were to compare the total area of our land territories and the sea areas under which we have certain rights under international law, look at that. On the screen is a very visual comparison of how different, how vast these areas are. This is more or less 7 times the area of the land. Okay? Some of these, such as the continental shelf and the exclusive economic zone, overlap to a large extent, as well as the EEZ and the contiguous zone. There are overlaps there, and that adds a bit to the confusion that most people have whenever you hear these terms and assert rights or entitlements over them. So hopefully, again, in the next few days, you will be able to clarify these various nuances. Next slide. And this is very important for us to do right now because, as we mentioned, we are a maritime and archipelagic nation, and yet it's only now that we are beginning to realize how valuable the maritime components of our archipelago is. Okay? This is based on the statistics of this is based on the data of the Philippine Statistics Authority, and they estimate that the ocean economy as of 2024 was already worth 1 trillion pesos. Divided into those various sectors, it's almost 4% of the gross domestic product. And the maritime activities, as you see, they are divided between fisheries, tourism, manufacturing in the coastal area, shipping and transportation through the waters, including the ports, and other activities, including oil and gas, potential oil and gas exploration activities. Okay. Next slide, please. And if you were to go to each quadrant of the sea areas that we have, no? And here I've divided it a little bit arbitrarily to the West Philippine Sea, the northern waters, the Philippine Sea, which is on the Pacific side, and the Sulu Celebes, which includes an archipelagic waters. You see here, this is a very visual infographic, shall we say, infographic showing the highlights of the values of each of these sea areas. And that, again, is to stress why we must hold the maritime components of our archipelago. We must keep it in mind. We must hold it to be one of our most important resource bases. It is the heritage not only of our current generation, but also of the future. Hence the importance of the Law of the Sea Convention, international law, because that is what will enable us to validly and lawfully protect and nurture what we have in these areas for now and for generations to come. And so hopefully by keeping that in mind over the next 2 days, taking that framework that as a maritime and archipelagic nation, we must be able to see and interpret and use the law in a way that protects these vital interests of our current and future generations. No? Hopefully that will then enable us to appreciate and understand why it is that the law of the sea is not only a very important and essential aspect of our foreign policy, but also an important part of our domestic law and policy. So thank you very much. We'll pause there for now.
You can now grab a quick snack or coffee outside. And when we return, we'll continue with the next session about the baselines, territorial sea, and associated navigational regimes. Please make sure to be back in your seats on time so we can stay on the schedule. Thank you.
Attorney J. Batumbakal on stage for the lecture.
Okay, good morning again. So we start off with a historical overview on the law of the sea and the Philippines, and I hope that we will be able to clarify some of these historical aspects so that it will help us understand the context and proper application of the law of the sea when we get to it in the session afterwards. Okay? Okay, click lang. Next slide. Medyo ano yata, you're too zoomed in. Yeah. Oh, now it's too distorted naman. Pwede bang iano mo? Yung aspect ratio standard mo. It's going to be very distorted kasi later. Okay? Anyway, so we'll talk about we'll have a brief history of the law of the sea, and then move into Southeast Asia, so that we'll have a little bit more regional context before diving into the Philippines and the law of the sea itself. Okay? Sige, next slide. Okay. Can you fix the distortion? Kasi the next slide has a video. So, sige, next slide. Yung aspect ratio, pakiayos. Yan. Okay, good. Better. Sige. Next slide. Yeah. So I always show this in my...
Ever since, people wanted to sail the seas, to discover and to trade overseas. During the age of the great discoveries, the early maritime powers, Spain and Portugal, demanded exclusive sovereignty over the seas, a battle which was settled, effectively dividing the Atlantic Ocean in two by Pope Alexander VI and by the Treaty of Tordesillas in 1493-94. Other powers did not accept this dispute settlement, particularly the French, Dutch and the English. Hugo Grotius, a Dutch legal scholar and early theorist of natural rights, published the book Mare Liberum in 1609 to establish a different legal understanding, the free sea.
Hugo Grotius is often called the father of modern international law. With his book Mare Liberum, he provided the legal basis for controversy and a change in legal understanding in times of the great discoveries and founding of colonies. He developed the freedom of navigation, which is valid for more than 400 years and still is.
This freedom of the seas was not unlimited. Coastal states claimed sovereignty over its coastal waters, both for economic as well as security interests. The breadth of the territorial sea was limited to 3 nautical miles, the range of a cannon mounted on the shore. The freedom of the seas and oceans was in place for many decades, without significant further development of the legal framework. 2 world wars, decolonization with tensions between industrialized and developing countries, the Cold War, as well as technological developments, the exploration of marine resources, overfishing, an increase in marine pollution and other marine uses, all this demanded for an international legal instrument for the seas and oceans. A legal order for the seas and oceans. But how? Through an enormous international effort. Since 1949, the international community discussed the law of the sea in the framework of the United Nations. Very long negotiations followed, with an interim solution in 1958. But it was only in 1982 that the United Nations Convention for the Law of the Sea was adopted, which entered into force in 1994.
The United Nations Convention on the Law of the Sea is based on consensus of the contracting states. The UN Convention for the Law of the Sea, often called the Constitution for the Oceans, reflects customary international law and is one of the most significant and visionary international instruments of our time. It will continue to contribute to the maintenance of peace, justice and progress for all peoples of the world.
From a legal freedom at sea through the free seas to the legal order for the seas and oceans today, a long way. But the challenges facing this legal order for the seas and oceans are constantly changing. The law of the sea has to be further developed continuously, for example, to promote the peaceful uses of the seas and oceans, the equitable and efficient utilization of their resources, the conservation of their living resources, and the study, protection, and preservation of the marine environment.
Okay, thank you. Now, this is, of course, from the Institute of the ISRIM, no? And you can find other subsequent videos detailing other more, the other components of the Law of the Sea Convention for your perusal. But this I find is a very good, huwag niyo naman ako igitna dyan. Dito mo lang. This I find is a very, very good video because it's short and sweet and succinct. It really condenses the history of the law of the sea in the international community in those few minutes. Okay, sige, next slide. Okay. Now, as you might know, if you're into maritime law, but if you're not, okay lang, the key influences over history when it comes to the Law of the Sea Convention, some of them are based on customs, rules, norms that date back to ancient times. No? Prior to the 17th century, you had ancient maritime customs, especially that developed out in the Mediterranean. You had the law of roads, which is a very special area in studies of maritime law, because the law of roads is actually an island out there among the Greek islands, and it basically became the foundation for maritime laws that are very familiar now. So things like jurisdiction over vessels, the fact that you can go to court to arrest a vessel in order to answer for obligations that it had taken, even though that vessel is not from your country, that is based on practices and customs dating back to the law of roads. And this we now know as admiralty jurisdiction. Many of the norms, the foundational norms in the admiralty jurisdiction can be traced way back, no, to that time. Sige, next slide. Now, what happened in the 17th century, why is it a milestone? Because that was when you had this clash of ideas in the international community at the time. The clash between mare liberum, or free seas, and mare clausum, or enclosed seas. No? These were positions taken by the maritime powers of the time, Great Britain and the Netherlands. Great Britain, however, was a naval power, while the Netherlands was a trading power, essentially. And as they spread out, no, and colonized various areas of the world, of course, they had to go through the sea. And the idea of whether the seas can be placed under the sovereignty of the state, no, that became an area of contest. Why? Because if seas can be treated like land, even though high seas could be treated like land, that they could be closed and controlled by the state, then anyone who wants to pass through them would have to contend with the laws and regulations of that state. For the Netherlands, as a growing trading power at the time, of course, it was not acceptable. Unlike for the UK, which was the ruler of the seven seas, of course, their interest was in control. For the Netherlands, their interest was in freedom to use the seas. Now, this clash of ideas in the international community, in a way, it's about the soul of international law when it comes to the sea, took place over that period of time. And in the end, no, the one that won out was basically mare liberum. Even the Brits realized that they needed that idea, that freedom of the seas, in order to be able to access, no, these far-off colonies and continue to trade and grow as a maritime trading power. Okay, sige, next slide. Now, still, despite that, no, despite the evolution of those customs and traditions and maritime norms, a lot of it was still, was unwritten because it was customary international law. It took all the way up to the 20th century to try to more or less concretize them and put them down into writing. Why? Because previously everybody just practiced it, assumed that everybody knew about it, no? But one very important question was, up to where does the territorial sea extend? No? Up to where does the state's sovereignty have force? Beyond which is the high seas, which is open to all. Okay, so even though you had that the acceptance of the maritime powers that the high seas is open to all and everybody has a territorial sea, there was no agreement on the boundary, where you put the boundary between the territorial sea and the high seas. So there were attempts to try to codify this in the 1920s and 1930s. Of course, that would be the European powers mainly, and they tried, at least they were able to agree on some principles that were already in place, no, from since ancient times, such as the separation of the territorial waters from the high seas. And they also now began documenting the state practice and customary international law when it came to practices to activities at sea. No? So, for example, rendering assistance to a ship in distress in the high seas. So they began to document that. But they still are not able to settle the fundamental issue up to where does the state sovereignty extend. Okay? Basically, the territorial sea boundary, where will you put it? Okay? Next slide. So things are still unsettled even during the Second World War. But because technology was developing, despite the war, changes were beginning to take place. One important change was the declaration of the continental shelf through the Truman Proclamation in 1945. This was not just an extension of the territorial sea. No, it was not that, because even the United States accepted that the territorial sea should be limited to only 3 nautical miles. But their problem was that they realized that important resources were located beyond 3 nautical miles, particularly offshore oil and gas. What happened in 1945 was that they invented offshore oil and gas technology, and their oil rigs began expanding out into the Gulf of Mexico, and they realized, my golly, the Gulf of Mexico is full of oil. And it was well beyond 3 nautical miles. So, in order to lay claim to resources beyond the territorial sea, the continental shelf doctrine was born. The Truman Proclamation, when you read it, is very, very carefully crafted, no? In that it zeroes in only on the natural resources of the seabed beyond the territorial sea. So, implicitly already accepting that the territorial sea remains, it remains limited as well, even though it doesn't say up to where. But beyond it is the high seas open to all, except that they now carved out this exception that when it comes to the natural resources of the continental shelf, beyond the territorial sea, that belongs to the coastal state. At the time, the only criteria that they put in place to define the continental shelf was either the 200-meter isobath, okay, which was more or less the edge of the geographic shelf, but since it is a depth, it is very irregular. It's a natural feature after all. And the second criteria was the depth of exploitability, the depth which admits of exploitation, okay? Which is a technological criteria, which is also very open-ended. It depends now on your technology. They realized that given even the limited reach that they had in 1945 and 46, no, they're probably only a few meters deep in this area. This is an extension from the coast. But then they had already begun development of the first offshore oil rig, which was operational by 1947. Then they realized that this could go even further than 200 meters. So that's why there was that depth of exploitability criteria. It was open-ended again. So at this time, both the territorial sea boundary and the continental shelf boundary was a little bit unclear, even though the rights to each zone was specified. Sige, next slide. Now, that led to efforts under the United Nations to try to continue this codification and settle the issues. Okay? And we had a series of United Nations conferences on the law of the sea. So that was the original definition of UNCLOS. No? That's what UNCLOS originally meant. You had the first conference and then the second conference. The first conference was in 1950s. It came up, eventually produced 4 conventions, the original Law of the Sea conventions, the Geneva Conventions on the Law of the Sea. That's the Convention on Territorial Sea and Contiguous Zone, Convention on the High Seas, Convention on Continental Shelf, and the Convention on Fishing and Conservation of Living Resources of the High Seas. All of them open for signature in 1958. So that's why you refer to them as 1958 Geneva Conventions on the Law of the Sea. During that time, the number of members of the United Nations was only around 40, I think 48, 49, including the Philippines. Okay? We were, after all, a founding member of the UN. But clearly, no, you have the situation of new nations coming into being because of the other policy, the other important work of the UN of decolonization. Okay? So the thing is, even though they came up with these 4 conventions, they still were unable to come to an agreement on the boundary of the territorial sea, where it is. Is it 3 nautical miles, 6, 12, 24? Some states began claiming 300, 350 nautical miles of territorial sea. So there's no agreement, even though you had agreement on what rights were applicable. Okay? So that was unsettled in 1958. They tried again in 1960. There were some more countries that had emerged during that time, and they still were not able to come to an agreement. Okay? Why? Because in 1960, what happened? By that time, you had the Cold War heating up, and the developing countries were basically in this situation being pulled in different directions by the competing maritime powers. Okay? And a lot of them simply did not want to be used, and while some of them had interests that were incompatible as far as they were concerned with the interests of the maritime powers of limiting the territorial sea. Okay? So it was still unsettled into the 1960s. Sige, next slide. What happened in the later part of the 1960s, however, was basically many things. No? Technology, basically. No? This was the height of the Cold War already, and there was the technological race between the US and the USSR. The superpower rivalry was moving into the oceans. Okay? You had naval frictions, US and Soviet ships playing chicken in the Mediterranean, coming into collision. Okay? Sounds familiar. Okay. And then there was even talk of basing nuclear weapons in the continental shelf, no? Not just on submarines, but in the seabed. You had a revival of many conflicting legal claims because without an agreement on the extent of the territorial sea, again, the old claims to 3, 12, 24, whatever, they began overlapping and they became sources of tensions. You had the rich potential of the seabed being realized because of exploration that had been taking place in the post-war period, particularly excitement over manganese nodules and deep seabed mining. What happened was that a vessel was able to scoop up parts of the seabed, and they examined all the rocks, and they found out that it was mostly valuable metals. Okay? If these things are, they're like this small sometimes, no? And they're heavy because they're mostly metal. And so there was excitement over the prospects of deep seabed mining. No? And then you had also overfishing taking place in various areas, no? And collapses of fish stocks in formerly rich fishing grounds. And marine pollution incidents. In the UK, you had the Torrey Canyon disaster. It was the first fully publicized and very widely covered oil spill. Okay? And so all the colored magazines, all the colored pictures in newspapers were featuring the impact of this oil spill in the UK. Was that in the Shetland Islands or somewhere? Anyway, basta one of their pristine areas. And then at the same time, you had the emergence of environmentalism. This is late 60s, beginning of the hippie era. But you also had Rachel Carson coming up with the Silent Spring, which called attention to the dangers of DDT being used in agriculture, the adverse effects on the environment of all these things. You had Jacques Cousteau in his TV series showing life and all of the different things, wondrous things underneath the sea. So all of this, naturally, were in the popular mind, of course, and they naturally also were in the minds of diplomats. So you had one person, the guy in the picture is Arvid Pardo, who comes from Malta, a little island nation, very small. You probably won't even see it on a map unless it's really, really zoomed in the Mediterranean. Last bastion of the Knights Templar, I think. And he basically made a speech in the UN General Assembly calling on the Assembly, calling their attention to all of these developments, and basically ringing the bell and saying that we need rules, we need law to try to address all of this. Otherwise, this will be the seeds of future conflict. And this time, everyone sort of agreed. Okay, sige, next slide. So that led eventually to the organization of the third UN Conference on the Law of the Sea, which took place over nearly a decade. Siyempre, well, it's not included there, it's the preparatory work, no? But over this decade, then, you had the first truly global multilateral negotiation process, okay? It became the template for all global agreements that followed. It was a very complex negotiation process because you had almost all members of the international community participating, and they had several different committees working on different aspects of the convention. You had both existing rules, such as in the 1958 Geneva Convention, being considered, incorporated into it, and adjusted and modified, no? And new rules being proposed and created. One of them is the concept of the exclusive economic zone, which we'll discuss a lot more of later. But basically, despite all of these complexities, the convention finally was able to reach agreement on the most important question that had not been answered for hundreds of years. Where is the limit of the territorial sea? They laid it at 12 nautical miles. But in order to get to that point, a lot of wheeling and dealing and compromises also had to be made, okay? Which resulted in a long and complex convention. Okay? So it opened for signature in 1982 and entered into force in 1994. And as of now, it is known as the law, really. There's no question that it is the law governing the oceans. Only a handful are not yet parties to it, and some of them, like the United States, despite being not a party to it, considers parts of it to be customary international law, binding upon it even though they have not ratified the treaty. Okay? So there's no question that the UN Convention on the Law of the Sea is probably the most important, one of the most important instruments produced by the international community in the modern era. Okay? Next slide. And it continues to evolve. No? Despite having been open for signature 82, there came a need to sort of amend parts of it in order to make it even more palatable and attractive to the industrial states who are holding out on certain provisions, particularly the deep seabed mining provisions. So in 1994, an implementing agreement was agreed upon, no, which effectively amended Part 11 on seabed mining to enable it to be ratified by the industrialized states. And once that came out, then more ratifications came in, allowing it to enter into force in November 1994. A year later, you had the UN Fish Stocks Agreement, which implements a few articles of the 82 Convention, Article 63 and 118 to 119, dealing with the management, conservation and management of fish stocks in the high seas, meaning they're beyond national jurisdiction. Okay? Clearly, during the negotiations up to 82, they could not have enough time or information to do it, so they decided to leave it for later, and they finally actually were able to negotiate a separate agreement on that. Okay? The UN Fish Stocks Agreement has become a basis now for what we know as the Conventions for Regional Fishery Management Organizations. These are international organizations that govern fishing in the high seas, and all of the sea areas of the world right now are covered by one or another international convention of an RFMO. Okay? And then recently we had, again, another additional instrument, the 2023 Agreement on the Conservation and Sustainable Use of Marine Biological Diversity of Areas Beyond National Jurisdiction. Mas madali sabihin, BBNJ, the BBNJ Agreement. Okay? It just entered into force January this year. Okay? And the Philippines already ratified it as well. Okay? So you see this continuous effort to progressively develop international law, especially at sea. Okay, next slide. So that's the bigger picture now on international law. What about within Southeast Asia? What was going on? How are they reacting to these developments? Okay, so next slide. First of all, remember that Southeast Asia, next slide. Yeah. Southeast Asia has a history that's different from those of the maritime powers. Southeast Asia was essentially colonized, no? Except for Thailand, which has managed to maintain itself despite this. But everyone else was subject to a colonial rule with different legal traditions, with different legal frameworks. Okay, so you'll notice the diversity not only in terms of geography, but also in terms of that legal tradition, the legal outlook. And this diversity remains influential up to now. On the geographic side, you'll notice that in the case of the Philippines, we are very different from the rest. Why? Because we are the only fully self-contained archipelagic nation. Unlike Indonesia, which is the largest archipelago, but it has certain parts which are part of other countries, PNG and Malaysia. No? So, but in terms of insularity, you could say that the Philippines and Indonesia as archipelagic countries at least have that particular character. The others have different ones. So on the Asian continent, what is now Cambodia, Laos, Myanmar, etc., those are basically continental countries. They're not insular countries. And they definitely have different interests in terms of their access to the sea, as well as the interest at sea. Is naturally very different. Their land base allows them also access to a much larger pool of land-based resources, unlike us. And their need is more for land transportation rather than sea transportation when it comes to distributing those resources internally. Okay? So these differences in geography, legal tradition, as well as their interest in the maritime activity, therefore defines their positioning during the UN Convention on the Law of the Sea negotiations. Okay, next slide. So you had, during the negotiations, you could classify their starting points between the insular and the peninsular and continental states. You had a group which you could characterize as being more insular, Philippines, Indonesia, and Singapore being among them, and the rest being more peninsular or continental, so Malaysia, Vietnam, Thailand, Cambodia, and Myanmar. Now, some of these countries, of course, like Timor-Leste, were not able to participate during that time. They were not yet independent at the time, but they have now basically acceded to or are now part of this set of rules that were negotiated ahead of them. Okay, next slide. Now, the key interests at play for Southeast Asia, given their colonial history, was basically, number one, sovereignty. Sovereignty was the driving motivation for them. They wanted to protect their sovereignty, which was, after all, hard won after colonial rule. And for the Indonesia and Philippines, particularly as archipelagos, their concern was sovereignty not only over the land, but over the inter-island archipelagic waters. Hence, the advocacy for recognition of the archipelagic state and archipelagic waters. Okay. In other aspects, you had control of shipping through straits used for international navigation, and here particularly Malaysia, Singapore, Indonesia, who all are co-located around one of the vital straits through the region, the Straits of Malacca and Singapore. They were all aligned with that concern of ensuring that they retain control over that area. And then for everyone, being developing nations, they wanted control of fishing in the offshore waters. They did not want the colonial powers to be able to continue to exploit them and take advantage of their weakness especially. And the same when it came to petroleum resources, because after all the capital and technology needed was with their former colonial masters. So these were the key interests that were motivating their positioning in the Law of the Sea conferences. Now, necessarily because they had different contexts to start with, the geography now comes into play. That led to slight differences in the way they were now negotiating and agreeing to various proposals. Those differences continue to influence how they're now, for example, relating to each other vis-a-vis China and the South China Sea. Okay, next slide. So the points of contention advocacy, however, despite those differences, they were able to make concrete contributions to the convention. On the part of the archipelagic states particularly, the recognition of the concept of the archipelagic state and archipelagic waters, the application of the baselines to archipelagic states, modification of territorial sea so that it's not measured only from the coastline but from the archipelagic baselines, recognition of sovereignty over the waters themselves, and all of this basically is encapsulated in Part 4. You could definitely say that Part 4 of the UN Convention on the Law of the Sea was a concrete contribution of the Philippines to the corpus of international law. Next, when it comes to control over straits used for international navigation, here you have Malaysia and Singapore particularly taking very strong positions on this. Indonesia in a more supporting role because they were also interested in the archipelagic part. Here, they took a very strong positioning when it came to the breadth of the territorial sea. Why? Because depending on how far the territorial sea was, the straits which they were concerned with may or may not be part of the high seas. Okay? So that's where their interest came into play. And then second, when it came to the determination of jurisdictions and straits used for international navigation enclosed by the territorial sea, once it became clear that the straits would be entirely enclosed within their territorial waters, no, that then led to contributions with respect to Part 3 of the Convention. Okay? So Part 2 and Part 3, Part 2 is territorial sea, Part 3 is straits used for international navigation. So these nations, together with other nations elsewhere in the world which were adjacent to international straits, all contributed to the establishment of the rules that are now contained in these two parts. Okay? And then everyone, especially since most of the Southeast Asian nations, or all of them were developing countries, everyone basically supported the establishment of the EEZ, which became Part 5 of the Convention. The EEZ was entirely new in international law. It was proposed by the developing countries in the course of the UNCLOS negotiations, particularly spearheaded by Kenya and the African states and states in Latin America. The idea was that, well, instead of claiming territorial seas of vast distances up to 350 nautical miles in the case of Ecuador, they eventually realized that the interest was not because of sovereignty, but rather because of the natural resources. No? They were motivated to extend their territorial seas because they were trying to capture the fisheries. Okay? And so when that became clear, no, the idea of an exclusive economic zone which entitled the state to the natural resources per se, not the entire area and the plenary powers of sovereignty, but rather through sovereign rights, which are akin to property rights. Okay? That was the breakthrough that was needed in order to eventually agree on the breadth of the territorial sea. For the maritime powers, no, from their perspective, extending the territorial sea up to several hundred miles was unacceptable because that would limit their mobility. However, if they agreed to the EEZ, which did not limit that mobility, then they could live with it. Okay? So that's why there was a consensus on that. And then lastly, the extension of the continental shelf up to 200 nautical miles and beyond, which is now contained in Part 6. That was very important because, as I showed you earlier, originally the continental shelf was very limited and a bit random, shall we say. Some countries were lucky to have wide continental shelves, others had none. But through the convention process, they just agreed that, okay, everything within 200 miles, which coincides with the original limit of the EEZ, everything underneath it is yours as continental shelf. Every natural resource in it is yours under the continental shelf doctrine. So everybody also agreed to it. So you could say that because of this, the convention is not, as some people would say, just an American invention or a Western rule imposed upon the developing countries. No. Okay? No, no, and no. It is the product of an extended negotiation process. No? It is a compromise, no, that was achieved not because it was imposed by a maritime power, but because it was negotiated, especially by the developing countries. Okay? So that has to be very clear. Okay? And next slide. And this is very important for us even now, because as you see in this slide, the extent of maritime activity, no, is illustrated here by the tracks of vessels across the region. Southeast Asia, if you'll notice in all of its ASEAN declarations, has always emphasized the importance of the UN Convention on the Law of the Sea as part of international law. And this is why Southeast Asia exists, survives, continues to thrive because of the maritime linkages, this network of maritime routes that enable them to trade with each other and the rest of the world. The fact that this happens, however, also presents with it its own challenges. Okay? Siyempre. So there's always a good and there's a bad. Okay? And that is why UNCLOS remains very important for Southeast Asia, despite some of the challenges that we're facing now. Okay? Sige. Next slide. Let's go now. Sige. Let's go now to the Philippines. Okay? Try to run through this quickly because I've been given the 3-minute mark. Okay. Sige. For the Philippines, we zero in now on the Philippines and how it was interacting with the UNCLOS negotiations. And I guess you could say that the main bones of contention between the Philippines internationally could all be encapsulated in the concept of the territorial sea. Again, next slide. Remember that when we were under Spain and the United States, pakiclick lang, these two colonial powers, pakiclick lang nung slide, basically treated the archipelago as a single entity, which is good, no? Because that is one of the reasons why we were able to strongly advocate for recognition of the archipelagic state. Okay, so again, next slide. However, when Spain transferred the Philippines to the US in 1898, they could not, as I mentioned earlier, enumerate each and every one of the islands, more than 7,000. And instead, they just identified the area wherein you will find the Philippine Islands. Isang click nga. So this is the Treaty of Paris, no? The Spanish cession to the United States. They described this box through a series of coordinates. Okay? However, the problem was that they missed some islands that were outside the box when you drew it, particularly down south, isa pang click, and up north. Okay? So na itsapuera sila. That's why it became necessary to enter into the Treaty of Washington. Why? Because when the Americans started taking over the Spanish garrisons, that's when they realized that these are outside the lines. So they came back, negotiated the Treaty of Washington to ensure that these islands, which were also under Spanish sovereignty at the time, were also included in the original cession to the US. Okay? And then later, the United States adjusted the treaty line up there, no? Around 1905. Yeah. And then you had the issue of the Turtle Islands. Why? Because the US was aware that the British were on North Borneo. Isang click. And so they negotiated eventually. Well, first they had a provisional agreement in 1907 because the Americans were busy with pacification and the Moro Wars. But eventually they were able to settle that and come to an agreement with the UK in 1930. Isang click. Okay? So that then created the US-UK Convention 1930, which drew that line down south. And together, all of these lines are what now were referred to as the international treaty limits. Okay? Sige, next. Scarborough Shoal presented a different problem. Okay, so sige, next. Because it was located outside the lines. However, upon correspondence between the Commonwealth government and the US, no, they realized that number one, it was administered by Spain as early as 1866, and then the United States afterwards. And because of those activities, or as those activities were taking place, no, by 1937, the Commonwealth government, no, realized the importance of the shoal and decided to make a formal inquiry to the US government. No? They basically asked, who has sovereignty over the shoal? Okay, sige, isang click. And the response of the United States was essentially that it should be considered as included among the remaining islands transferred by the Treaty of Washington in 1900. Why? Because Spain had been administering it and did surveys on it. And if those can be considered as a claim of title, then therefore it is covered by the Treaty of Washington. Okay, so that is now the basis of our sovereignty there. So the US formally agreed with the Philippines acquisition of shoal in 1937, and we have copies of the actual correspondence here. Okay, and so afterwards, the Philippines continued to administer the shoal. Okay, now the continental shelf, as you mentioned, came up 1945. The Philippines was the first country in this region to actually lay claim to a continental shelf, even though it wasn't a continent. Okay, so isang click. In 1947, through Proclamation 370, we laid claim to it, the continental shelf or its analog in an archipelago. And basically those lines describe, no, the 200-meter isobath, that's the one closer, the inner line, and the deeper portion. Okay, the potential depth of exploitability. Teka, balik mo nga sa kanina, sa earlier. Yan. And you'll notice immediately, again, what I mentioned earlier about the disadvantage of this being so irregular. Some areas of the country have wide continental shelves like Palawan. Others, like the eastern part of Luzon, practically none. eastern part of Mindanao, and Samar, so practically none. Okay? So it's very random because it's a natural feature. So again, next slide. Now, 1952, in the run-up to negotiations for the Law of the Sea Convention, the first conference was being organized. The UN asked a question, circulated a question among all the coastal states, what should be the breadth of the territorial sea? Up to where should the territorial sea extend? The Philippines' answer was not a distance, but the archipelagic doctrine. So again, next. And essentially, isang click. In the note verbal in 1955, this is the first time we formally claimed territorial waters up to the limits of the three treaties, yung box. Okay? That's the international treaty limits. And however, we did not distinguish between internal waters and archipelagic waters. We just said that all of these are inland and territorial waters. That created a problem. Okay? And that problem was a little bit exacerbated when we tried to adjust our legislation through RA 3046, the first baselines law in 1961. That's where we tried to adjust. We said that all waters inside the baselines, because it drew baselines, those are our internal waters. Everything outside of the treaty limits are the territorial waters. Okay? So no breadth, again, no standard breadth. Problem, it had typographical errors resulting in the polygon not closing properly. Kaya naligaw yung ibang base points. So we had to amend it and correct it. So next slide. 1968, we enacted RA 5446 to correct those errors, and also by that time, we put in the second provision that this is without prejudice to the claim to Sabah. Okay, now I know it's still controversial, okay, but this I'm just stating what was the law. The claim was announced only in 1962 after the first baselines law was enacted, so they had to adjust it there. Okay, however, that's an aside because after all, this is about the sea. It, however, maintained the claim to territorial waters and internal waters made under 3046. So again, internal waters, everything within the baselines, territorial waters out, all the way up to the treaty limits. Okay, next slide. That, of course, created problems because no state recognized that. And then in 1978, we declared that we had already occupied the Calayan Islands. Actually, we started as early as 68. But by 78, we felt that, I guess we felt confident enough that we now created the municipality, and in order to establish the boundary of the municipality, we tried to amend unilaterally the international treaty limits by creating that additional area, the box. So we declared our acquisition sovereignty. However, at the same time, we also declared an EEZ, which created a problem because that means that everything here is not subject to sovereignty but only sovereign rights. Everything outside is subject to full sovereignty. Not very consistent. And that encapsulated our difficulties with the law of the sea throughout the 70s and 80s and even up to the 90s. Okay, sige, next slide. The problem was very clearly anticipated already during the ratification of the Law of the Sea Convention. You had Arturo Tolentino, who was head of the delegation, very clearly stating the problem with the Treaty of Paris limits. Nobody accepted it. They tried and tried over decades, still no success. And it will become increasingly problematic when the Law of the Sea Convention becomes international law. They already knew that it was going to become the international law. Okay, next slide. So they presented it this way. Either we continue to claim the Treaty of Paris limits, which is that box, which will not be recognized, or we claim in accordance with international law, which will enable us to have access to resources over an even larger area than what we originally claimed. So the choice for them was clear. We go with UNCLOS because UNCLOS systems will be recognized by other countries, whereas the Treaty of Paris will never be. Okay, next slide. Also, in UNCLOS, they stress this, the legal unification of the land and waters of the archipelago was recognized, okay, as well as the vast resources. Without it, all our inter-island waters will be the high seas, open to all nations. Even the Sulu Sea, even the area between Batangas and Mindoro would be the high seas. That was not acceptable. Clearly, it was better for us to go with UNCLOS rather than an unrecognized Treaty of Paris claims, while the rest of the international community asserts something that is far, far away from our interest. Okay? Sige, next slide. So that's why in the maritime zones are fully covered by the general description in our constitution with national territory, which again distinguishes between the Philippine archipelago and all other territories, okay, over which we have sovereignty jurisdiction, and it mentions the territorial sea, seabed, subsoil, insular shelves, and other submarine areas as well, recognizing that some of these might not be subject to sovereignty but merely jurisdiction or sovereign rights. Sige. Next slide. Furthermore, it recognizes archipelagic waters, territorial sea, exclusive economic zone, all, two of which are UNCLOS-based terminologies. Okay? So we enacted eventually, we had committed to harmonize our laws with UNCLOS. Eventually we enacted RA 9522, which created the baselines from which are now measured all the maritime zones based on UNCLOS. Okay? And the constitutionality of these baselines were affirmed by the Supreme Court unanimously in the case of Magallona versus Executive Secretary in 2011, okay? Penned by Justice Carpio, who's with us today. With these compliant baselines, we also demonstrated our implementation of UNCLOS when we laid the claim to the extended continental shelf in the Benham Rice region. That additional area in white, that adds to our resource base, because it means that all the natural resources in the seabed in that area is also now part of our continental shelf. Originally, it's only up to 200 nautical miles, but here, umusad pa ng konti. Based on, again, on the criteria in UNCLOS. Next slide. When the arbitration decision came out, it further vindicated our position. Of course, it's 501 pages. Basahin nyo na lang in your own time. Okay yun. I mean, maganda pang patulog yun. Very educational. If you can't read it, you put it on there. You might get it by osmosis, di ba? Anyway, the key takeaways are that number one, China's excessive claim to the South China Sea, which would basically take away our EEZ, that was invalidated. Isang click. Okay? That allows us, isa pang click, allows us to lay claim to the EEZ and continental shelf, to the west of the archipelago, which we now collectively refer to as the West Philippine Sea. Okay? Para mas madali sabihin, West Philippine Sea lang, kaysa naman the exclusive economic zone within 200 nautical miles and the continental shelf within 200 nautical miles plus the continental shelf beyond 200 nautical miles in the West Philippine, in the South China Sea. Haba, okay? West Philippine Sea lang. And then what remains now to be disputed is just the sovereignty over the islands and high tide elevations there, and by implication, the territorial sea that's around, that attaches to them. That is the one that is still unresolved. The South China Sea arbitration did not address sovereignty issues. It was only the maritime issues around them. Okay? And then last 2024, we further implemented UNCLOS by laying claim, isa pang slide. Okay. Okay. Nawala yung sa continental shelf. Anyway, sige. Sige, yan na lang. So, very clear, that we have, ito yun, yung 2024 relayed claim to this additional area of extended continental shelf. Okay? But that is still pending. It's not, and probably the Commission might not deal with it fully because it is subject to dispute. It's part of the maritime disputes. Okay, now, the layout, therefore, of our sovereignty, sovereign rights, and jurisdictions are laid out in this map. You have absolute sovereignty over the land, sovereignty subject to passage rights of foreign vessels in our territorial waters and archipelagic waters. You have exclusive sovereign rights in our EEZ and continental shelf, beyond which is now the high seas open for all. Okay, again, next slide. Yun. Medyo na yung sequence. Okay, so all of that is now incorporated into domestic law. Even the provisions of UNCLOS have now been essentially transformed into domestic law through the Philippine Maritime Zones Act enacted in 2024, RA 12064. All the maritime zones are declared and laid out. The rights and obligations of foreign states vis-a-vis the coastal state, i.e. the Philippines, are also referred to and laid out. So the sovereignty and jurisdictions of the Philippines are clarified. And the rights and duties of foreign ships and aircraft through those zones are also clarified. So we have basically been implementing UNCLOS through RA 3064, as well as the subsequent law, the RA 3065, which is the Archipelagic Sea Lanes Act. Okay? And most important there, we made sure to include a provision which will allow us to address potential abuses of these rights in case some nations try to take advantage of their rights under UNCLOS, but on the other hand, refuse to recognize our rights under UNCLOS in the areas that claim. Okay? So that, in a nutshell, is the history that has brought us to today. And this is just an estimation, my own estimation, of the areas and the configuration of the zones. Anyway, you'll get it in the handouts for later perusal. More exact computations hopefully will be forthcoming from NAMRIA later on. Okay? So with that, thank you very much for listening. I'm open for questions.
Nautical square miles. That we lost 242,000 nautical square miles because of 9522.
Who
and
said
because Marcoleta.
Honestly. No, I think it's very clear now. I mean, you have a choice. Either push on with a claim that has already been rejected repeatedly over 3 decades. That's the Treaty of Paris lines. Giving you maybe an area, covering an area of what, 142,000? Kanina nandun sa ni Tolentino yan, yung numbers, no? Push on with that and not be recognized as an archipelagic state. Your inter-island waters, the international community will insist that it is the high seas because you're not part of UNCLOS. Or do that, or accept compliance with UNCLOS, implement UNCLOS, where you will get not only recognition of sovereignty over the inter-island waters, but also the EEZ and continental shelf expansion up to 200 nautical miles.
But would his claim be uniform with Merlin's position? Merlin, Magallona, yung position in Marcoleta.
Yeah. Prof. Magallona, God rest his soul, was clearly an advocate of the Treaty of Paris lines. Okay? In fact, Magallona versus Secretary asserted that. No? But the Supreme Court unanimously disagreed, essentially. No? And the thing was that the Treaty of Paris lines argument was based on an insistence that those lines mark the territorial boundary of the Philippines on the basis of succession from the previous powers, the US and Spain. When you look at the US and in Spanish positions prior to that, they never enforced that as a territorial boundary. And in fact, the US only recognized and enforced in the Philippines a 3 nautical mile territorial sea. You see that in 2 cases of the Supreme Court decided during that time, US versus Wong Cheng and, I forget the first one. No? But basically they were talking about the crime of smoking opium committed on board a ship in Manila Bay. And it is mentioned there that once they came within the 3 nautical miles of the headlands of the Manila Bay, they were subject to Philippine jurisdiction, and that 3 nautical miles clearly refers to the 3 nautical mile territorial sea. No? After all, it's a criminal case. No? Now the name escapes me. The other case escapes me. US versus something. Anyway, yeah, it'll come back to me later. Yeah. Yes.
Good morning, Professor. I'm just thinking now, how would you assess the net benefit of the UNCLOS, particularly on the recognition of the archipelagic doctrine to the Philippines, when it seems like Indonesia, Philippines, and very few states are the archipelagos, but it is contrary to our national position, I guess before, where we consider them inland waters, therefore subject to full sovereignty. But as you said, the rest of the world considers them as high seas. So it seems to me that the benefit is just that recognition from the other states. But for us that are the actual archipelagos, it seems that our interests were lessened. So how would you assess that effect, sir?
Number one, there are two separate things you need to consider. One is the passage of foreign vessels through the waters, and the other is the claim to resources within those waters. Okay. When it comes to the claims to resources within those waters, inter-island waters, as well as the exercise of rights of sovereignty, not just sovereign rights, in archipelagic waters, no, it's a clear win. Why? Because, as I showed earlier, if we did not have the archipelagic doctrine, if it was not recognized, then all other states will insist that waters of the Philippines beyond 12 nautical miles from each island are the high seas, open to them, even to the point of exploitation of natural resources. So the Sulu Sea would become a common area for all nations. Unahan na lang kung sino maunang makakuha ng fisheries, petroleum, minerals in the Sulu Sea. Even parts of the Visayan Sea would become the high seas, no, based on that. I had another slide which had that, but I didn't have to show it here. No? Butas-butas bale yung archipelago, if that were to take place. So the recognition of the concept of the archipelagic state, enabling us to draw baselines to enclose the entire Luzon, Visayas, and Mindanao into one unit, no? And recognizing that all of those areas are under our sovereignty, no? That is what now protects us. That is what enables us to have exclusive sovereignty over resources in the Sulu Sea, Visayan Sea, and everywhere else. Okay. So that's a clear win. That's why Tolentino referred to the unification, the legal unification of the land and waters of the archipelago. Okay, now, of course, this is an international agreement with the international community, so it's a give and take situation. One key area now is the second part, the passage of foreign vessels through these inter-island waters. The thing is, everybody seemed to assume that prior to UNCLOS, no foreign vessels entered our inter-island waters. Yun yung assumption that you get. We will open our inter-island waters to international traffic. That was one of the arguments, for example, being made constantly in this regard. But when you look at history, that was never true. Our inter-island waters have always been open to international traffic. Okay? Maybe later I can show you, I'll add it in the slides later, showing that even 1898, when the Americans came, they already mapped out the routes, the trading routes through the Philippines. No? These are already subject, basically, to international navigation even before. And when you look at the history of Spanish colonization, for example, no, the whole point of them being able to get to Manila was because they passed through inter-island waters. And all other nations as well, which traded with Spain, despite the monopoly that they had, were also passing through here. Some of the key historical events were because of this idea that Spain should close these waters, but hindi naman nila nagawa. When the British invaded the Philippines and took over Manila for 2 years, for example, one of the first things they did was to make it very clear that all these inter-island waters are open to international navigation. Okay? When the United States entered into an agreement with the Sultan of Sulu for trade, no? This was during the Spanish era. One of the key points that were contained in that agreement was the ability, basically the permission or the ability of the United States to fly through or sail through these waters, no, in order to get to Sulu. No? So they've always been open to international traffic. So the fact that we ratified UNCLOS actually did not change the situation. And arguably, we also benefited from that. The whole reason why we have several international ports from Manila to Cebu, Iloilo, etc., it's because of their access, direct access to international maritime traffic. If international traffic never came into our shores, they would all be going to Manila and not be able to go to all of these others. No? So it's, for me, when it comes to that argument about opening the seas to international traffic, it's, number one, based on a mistaken assumption that they were closed before. No? But I do recognize that that brings it with certain challenges of regulation. No? But UNCLOS also provides, as we'll show you, as will be seen later, also provides the basis for us to regulate the activities of these vessels if they do anything more than passing through. Okay? If they try to smuggle, if they try to fish, etc., we can take action against them based on UNCLOS. So at least clear then that UNCLOS also addresses our interest in that regard. So overall, it's much better for us, I think. No?
Thank you very much, sir. This time, we'd like to remind our participants to kindly reserve your questions at the end of the second session. For Professor Batambacal will be back on stage later. Thank you very much, sir. Let's give a round of applause to Professor J. Batambacal, please. Lines, territorial sea, and associated navigational regimes. So this lecture examines the legal foundations of baselines in the territorial sea under the United Nations Convention of the Law of the Sea, or UNCLOS, situating them within the historical development of the Philippine maritime law. This time, we'd like to request here on stage Professor Natalie Klein for the lecture, to be joined by Attorney J. Batambacal for the Philippine perspective.
All right. Thank you very much for the introduction, and thank you very much to the organizers of WPS for the opportunity to come and speak with you today and be part of this national symposium on the law of the sea. My topic is going to, in some ways, put a further layer on what you have heard about the historical development of the law of the sea, and then Professor Jay will be back to give you more of a perspective from the Philippines. So what I'm going to be covering concerns really the starting point when we're talking about maritime zones, because I think when we look at the oceans, you see this beautiful blue expanse of water. But when you are somebody who works in law of the sea, what you know is that beautiful blue expanse of water is actually divided up into many different maritime zones. So when we're going to be talking about the different maritime zones, we have to have a clear idea of how we measure them. And our starting point for measuring maritime zones is talking about the territorial sea, talking about the first maritime zone over which states exercise sovereignty as they project from those baselines. So if we can go to the first slide. Thank you. So you'll see from this graphic that we go through and there we go. We draw the baselines that become the starting point from which all the other maritime zones are measured. First of all, the territorial sea leading to the contiguous zone, and from there to the exclusive economic zone, potentially out further for the continental shelf and allowing for the area and the high seas. So that shows you very vividly, and I saw at the start of the program as well, you've got a nice depiction of how we need the baselines as our starting point to then determine the maritime zones that all fall from that. So when we're trying to figure out what our baselines are, we talk about them being measured from the coastline and refer to a normal baseline as being the low water line along the coast. So you can see from the graphic on the screen that there is a distinction that is drawn between the low tide point and then the high tide point. So the normal baseline favors the low water mark, and I think this picture is kind of nice as it gives you a sense of why that particularly matters. Because if you remember the first graphic, it's like, well, we're going to be measuring all of our different maritime zones from this particular baseline. So if you're starting with the low tide point, then you're already essentially pushing out a little bit further in terms of the line from which you are going to be measuring all of your different maritime zones. So we draw that distinction between the low tide point and the high tide point. There are different technicalities that come in about how that's measured, but I think that's probably the main point to bear in mind is we need to know what the low tide point is. But you also start getting a sense when you're thinking about baselines about why the issue of sea level rise is then important, because at the point that the sea starts creeping up further onto land, imagine as the waters rise, they're getting closer to that high tide point, then that means you're also moving back the line from which you start measuring all of your different maritime zones. And so all those maritime zones become closer to land. So this is why there's a really strong issue for island states in thinking about where those baselines are and whether it is possible to set those baselines to be applicable longer term. So if we can go to the next slide, please. Now, it's fairly straightforward. You might think if you have a coastline, we're just going to draw particular points or lines all along the coast. But of course, you know that no coastline is completely smooth and regular. Instead, there's always going to be a whole range of different features along the coastline, including the fact that rivers are going to flow into the ocean and we have to draw lines across the mouths of rivers. So we have different types of closing lines that also then become part of the baselines from which we measure our different maritime zones. So UNCLOS has rules about how we set closing lines across the mouths of rivers. UNCLOS also allows for the reality that, of course, we have ports, sometimes massive megaports. The photo down the bottom is one of the largest ports of the world, through to one of the smallest ports in the world. And they also get taken into account when we're trying to determine the different points along a coast from which we measure our baselines. One particularly difficult geographical feature to deal with relates to bays. And if we can just go back once more, I just wanted to point out with the Gulf of Sidra, the bay in relation off the coast of Libya, where Libya decided that the Gulf of Sidra constituted a historic bay and drew an extremely long closing line enclosing the Gulf of Sidra as internal waters. So once it closes that area as internal waters, it's restricting the navigation of all other states. So the stakes were fairly high for Libya when it did that. It resulted in some military confrontations between Libya and the United States. And we continue to have debates about how we draw these particular lines for bays. So if we can go to the next one now, please. And we'll just let all the different graphics go. This is courtesy of Clive Schofield and one of his colleagues. So if we can just press through. Thank you. So there's a whole range of different considerations when we're drawing closing lines for bays. One of the first considerations we have is what is the area of the body of water behind the closing line. So the very top one shows you that in fact there is not enough water area behind that closing line for that to be enclosed as a bay. You'll see the second one does actually have a larger area of water behind it, so it does allow for the possibility of the closing line to be drawn there. When you get to a situation where there's a bay with several different islands across it, then we potentially draw the different lines, and if we continue on, then we have to see to what extent that the total number of closing lines then produces the semicircle, which you'll see next. And there you go. So the semicircle there and the total width allows for that area to be counted as part of the bay. If we continue, there we go. So another consideration when we're drawing a closing line for a bay, and thinking back to the example we saw with the Gulf of Sidra, is what is the total length of a line that you can have across that. So you'll see in this example, if we keep clicking through, is that there is a maximum closing line of 24 nautical miles. So if the mouth of the bay is actually wider, then we gradually have to move that back until it is the correct breadth. So it gets quite technical in how you draw the different closing lines across bays. So the key thing to bear in mind is that we do have some restrictions on how this works. The measurements really do matter. And it can then also matter a lot for states in terms of determining their projection of the maritime zones from these particular lines that are drawn. All right, if we can move on. So I've mentioned the use of baselines for measuring the different maritime zones. And one of the other things to bear in mind is that the baseline also separates some maritime areas that are on the landward side of the baseline. So thinking back to all those waters that were getting closed in by the bays, they will constitute internal waters. And then you'll see from there we head out to the territorial sea. So next slide, please. So the internal waters have been described as an area where there's more or less a close relationship existing between certain sea areas and the land formations which divide or surround them. So we're talking about areas of water where there is a very close connection to the land. And in that particular area, a state will have complete sovereignty, be able to exercise its civil and criminal jurisdiction over every vessel within that, with, of course, a few small exceptions, notably in relation to immunity of warships that will continue to exist within internal waters. So another important baseline to bear in mind is the use of straight baselines. So these were developed by the International Court of Justice in the Anglo-Norwegian fisheries case. And you can see on the picture there the coastline of Norway. And it was a fairly distinct coastline and had become problematic between the United Kingdom and Norway because Norway was using these straight baselines as a way of trying to essentially, smooth out its coastline. If you have a very jagged coastline, and then that means you have to have very jagged maritime zones that fall from it. So there's some common sense, and particularly useful for maritime safety and navigation, if you can have these lines that will smooth out a coastline. So if you see something like the coastline of Norway, which has many deep indentations, many islands along it, then it makes sense to draw these lines that will otherwise make this a much smoother coastline. And that means it's also, when you're projecting your maritime areas, the subsequent maritime boundaries that extend out also have clearer lines. And it just makes it easier when you're trying to determine, well, who has what rights in which particular area. So the International Court of Justice realised or recognised that there was a good reason for using straight baselines where a coastline was deeply indented, where there were these fringing islands, where it followed the general direction of the coast. And the standard that the ICJ adopted in that particular case was then reflected in the Territorial Sea Convention. Professor Jay mentioned the 1958 Territorial Sea Convention, and then it was pretty much repeated when we got to the adoption of UNCLOS, and has recently been reaffirmed by the International Court of Justice, where it really, more recently in this dispute between Colombia and Nicaragua, I think affirmed that finding the correct criteria for the application of straight baselines is quite critical. Next slide, please. So Article 7 of the UN Convention on the Law of the Sea sets out the different criteria that we're looking for. So if you're thinking about when can a state use straight baselines, it's when it's deeply indented and cut into, where there is a fringe of islands. The idea that drawing these, you have to kind of follow the general shape of the coast. And it has to be sufficiently linked to the land domain, because by drawing a straight baseline, you're essentially creating more internal waters. So you're creating more of an area over which a state has complete sovereignty. So it needs to have that connection. Also potentially taken into account will be the economic interests peculiar to the region concerned. So there's a whole range of considerations that a state must take into account to determine if it can draw these straight baselines. The problem has been that not every state has followed these particular rules very closely. So if we can move on to the next slide. So, well, another of Clive's animations, which will show you, if you can click through, the effect of drawing straight baselines that essentially smooths out. If we continue on, there we go, how we end up drawing those straight baselines. So if we can go on one more, thank you. So what has happened with the drawing of straight baselines is that states have not always followed these criteria as closely as they should. So the United States has followed a freedom of navigation operations program where it routinely protests. And some of these examples have been compiled in this book. And one of these examples, I just wanted to give you a sense of what some countries have been doing and why it is a problem. So if you look at this example from Venezuela, I always like showing this one to my students and saying, well, can you see what the problems are here? Unfortunately, they almost always go, but hang on, can you draw a straight baseline that actually lands on another country? So no, actually, that is not one of the criteria. So that is immediately a problem if you have a straight baseline that you are trying to connect to a point on another country's territory. But even if you were to put aside the fact that Venezuela's straight baseline lands on Guyana, you also go, okay, well, there is definitely a fringe of islands there. That is true. But the problem is the straight baseline does not follow the general direction of those islands. Instead, it cuts right across from them. So normally you could imagine that there might be a straight baseline coming down from point A and heading south, but that is not what Venezuela has done. But drawing a straight baseline, that it effectively encloses a bigger maritime area, which becomes the internal waters and then allows a state to project even further. Let's look at another example closer to home here. And it's a little difficult to see, but hopefully you can pick out the straight baselines that have been drawn by Vietnam around its coast. So think back to those criteria that we talked about. Is the coastline of Vietnam deeply indented? Is there a fringe of islands around it? There are some little islands around the side that Vietnam has relied upon, but I don't think this looks like the coastline of Norway. It's not really an equivalent, and there have been protests to Vietnam about the straight baselines it has drawn, and which again provides Vietnam then potentially with a basis to try and push its baselines out further, or its maritime zones out further. Next example. So here we see an example of Ecuador and its claimed straight baselines and maritime boundaries. But again, the question you need to ask yourself when you're looking at the coastline of Ecuador, is this a coastline that is deeply indented? Does it have a fringe of islands? So this is the problem that we have now run into with the use of straight baselines, where something that made sense when we looked at the coastline of Norway, and that certainly makes sense in different parts of coastal areas for many different countries, have now unfortunately been exploited by many different states. I've picked out 3 examples, but there are many others where there can be legitimate questions raised, and certainly the United States has protested some of Australia's baselines as well. So how these lines get drawn then becomes controversial because it affects the area in which other states can navigate and what rights of navigation they have. It affects the extent that a coastal state can then claim rights for licensing fishing or for licensing oil activities. So the baselines on the one hand, technical matter, but it matters a lot in terms of the maritime zones. All right, next slide, please. Okay, so moving now from baselines, and I might be going a bit too quickly, but I'm happy to take questions afterwards. But I wanted to move on to the territorial sea. So the baseline is noted there, and then the territorial sea is measured from that baseline up to 12 nautical miles. And as Professor Jay said, this was a controversy, but it was settled under UNCLOS that the territorial sea could extend up to 12 nautical miles from the baseline that's drawn on the land. Next, please. All right, so what we need to always bear in mind is the legal status of these different maritime areas. So with the internal waters, as I mentioned, that's an area which is subject to the complete sovereignty of a state. Similarly, for the territorial sea, that is an area that is subject to the sovereignty of the coastal state. That sovereignty covers not only the water column, but also the seabed and the airspace above it. Also true for internal waters. The one big exception with the territorial sea is that the vessels of every other state have a right of innocent passage to be able to traverse the territorial sea. The idea that ships, for the exercise of their navigational rights, can move through these waters continuously and expeditiously. So the sovereignty of a coastal state is limited in the territorial sea by the right of innocent passage, and the coastal state can agree to other limitations in its territorial sea through treaty, but that's all predicated on the consent of the coastal state. Next, please. All right, so importantly for a coastal state is its ability to be able to prescribe laws and then enforce those laws in its territorial sea. So one of the key issues that comes up, of course, is potentially in terms of maritime security, responding to criminal acts that might happen within the territorial sea of a state. Under UNCLOS, Article 27 gives the coastal state rights to be able to exercise criminal law enforcement powers. It's critically important for a state to be able to arrest vessels that are engaged in criminal activities, that there is the necessary underlying domestic legislation that criminalizes that activity. Article 28 also gives a right to exercise civil jurisdiction. Next slide, please. All right, because a coastal state has sovereignty over its territorial sea, that means that it is the only state to be allowed to exercise policing powers in its territorial sea. No other state can come in and exercise policing powers in a state's territorial sea unless the coastal state consents to it. And coastal states will consent on occasions for that. So, for example, there's a maritime security agreement that's in place in the Caribbean. Well, it's been negotiated, it hasn't entered into force, but that treaty potentially allows for law enforcement actions to be undertaken in the territorial sea of the states that are party to that particular treaty. So sometimes in order to enhance efforts to respond to illegal fishing, states will enter into shipwrighter agreements where they might allow the Coast Guard from another state to be able to conduct policing in the territorial sea or to continue hot pursuit into their territorial sea. So where there's cooperation that is critical to a state and there is consent for that kind of policing, it can happen within the territorial sea. Also, the Security Council can authorize those actions, and it did so when it was trying to respond to the increase in piracy attacks off the coast of Somalia. But it was done with the consent of the Somali transitional government at the time. All right, next slide, please. All right, so beyond law enforcement powers, it's critical to bear in mind the navigational rights that exist within the territorial sea. So this is the right of innocent passage that I mentioned before. And ships of all states enjoy the right of innocent passage through the territorial sea, and it still falls to the coastal state to take necessary steps in its territorial sea to prevent passage that is not innocent. So even beyond its law enforcement powers, a coastal state can take steps to prevent passage that is not innocent. The question then, of course, is, well, what counts as innocent passage? So next slide. Passage will be considered innocent if it is not prejudicial to the peace, good order, or security of the coastal state. Of course, that's a very broad statement, and then the question becomes, well, what counts as the peace, good order, or security of the coastal state? So under the terms of UNCLOS, Article 19 goes through and it lists a whole range of activities which will count as prejudicial to the peace, order, or good security of a state. So that will include undertaking surveillance, undertaking fishing activities, if there's customs infringements, a whole range of different military activities, whether it is intelligence gathering or propaganda activities. All of these particular activities, anything that essentially is not continuous and expeditious passage through the territorial sea can potentially count as being prejudicial to the peace, good order, or security of the coastal state. Article 19, back one, can get very broad in terms of referring to any activity not having a direct bearing on passage. So it's quite a catch-all consideration. So the emphasis in determining what counts as innocent passage is looking at what a ship is actually doing. So that emphasis is important because ships can sail through, and perhaps the very fact that a ship is sailing through, if it is a warship, that some coastal states will consider it threatening, that a warship is coming so close to its coastline. But if it is just sailing through, then that is the exercise of the right of innocent passage. And the International Court of Justice did actually consider this in the very first case that it ever decided, which was the Corfu Channel case between the United Kingdom and Albania. And the United Kingdom had, diplomatic statements at the time saying that it was seeking to test the resolve of Albania in sending its warships through this particular strait. But the ships were just sailing through. And as a result, the court said, well, even though there was this intention behind it, what mattered was how those ships were sailing through. So that is really one of your critical assessments when you're considering, is this ship violating innocent passage? What is it actually doing? Not just what you think it might be intending to do by coming through. That could get very speculative, and probably there is some diplomatic issues that might be going on, but that doesn't change your legal characterization. So the acts that are undertaken by the vessel inform the nature of the passage, rather than the mere fact of it's a warship. It might be a very large warship, but if that very large warship is continuing continuously and expeditiously, then that is exercising the right of innocent passage. Next one now, please. So, of course, the controversy is with warships coming through the territorial sea. And it has been established quite early on that warships and also other government ships engaged in non-commercial service similarly enjoy a right of innocent passage. What has been controversial is whether a foreign warship coming through a territorial sea has to give notice or seek permission to come through. The majority of states now take the view that no such requirements are in place, but there still remains a strong minority of countries that have legislation in place insisting on either prior notice or prior authorization. In my view, for whatever my particular view is worth on this matter, I don't think seeking prior notification is problematic, but it does run contrary to UNCLOS if you are seeking prior authorization from a warship. If you were requiring permission for a warship to be able to come through the territorial sea, then you are effectively hampering that passage and potentially denying a right of innocent passage that exists. So to my mind, seeking authorization is far more problematic than prior notice. And if you have to give prior notice under domestic legislation and a country fails to give that notice, then that is a factor that a coastal state can then take into consideration in assessing that particular passage to determine if it is, the activities that are happening or whether they are innocent or not. But this is a point that does remain controversial in the practice of different states. Now, if there is a warship that does undertake intelligence activities or other actions, tests weapons, or in other ways taking steps that are prejudicial to the peace, good order, or security of the coastal state, and it is in non-compliance with the right of innocent passage, because a warship enjoys sovereign immunity, a coastal state is very limited in the actions it can take against a warship that is violating sovereign immunity. All it can do is require it to leave the territorial sea immediately. So a coastal state can ask the warship to leave. Some coastal states interpret how it asks a warship to leave quite liberally, and will say, well, I'm asking it to leave by shouldering it, or I'm asking it to leave by coming very close and shining very bright lights at it. So there are other considerations that come in, but the key rule is the idea that a warship enjoys sovereign immunity, and so the interference that it can experience from other countries is very limited. All right, next slide, please. So just to finish with a couple of examples before handing over to Professor Jay to talk more about the Philippines perspective. I wanted to give you some examples from the United States FONOPS, or the Freedom of Navigation Operations. There's a whole series of these available on the Belfer Center website if you want to have a look. So some of the examples of the US undertaking these freedom of navigation programs is it takes an example like the Fiery Cross Reef, and will send a warship through, and will do so without giving prior notice or authorization, because the United States completely rejects the idea that is required for the exercise of the right of innocent passage. So in terms of coming through, the idea is to reject the possibility that there is such a requirement under international law. In addition, the United States has also been taking steps in relation to the breadth of the different maritime zones that are being claimed from states. And in some of the FONOPS where there is a low tide elevation, then it will also reject the idea that there is a right of innocent passage. So if we just go to the next example, I think that's one where you can see that, yes. So Mischief Reef, as it's called here, as a low tide elevation, is not entitled to its own territorial sea. So then what the United States does in its FONOPS is that it sails a warship through, it zigzags about because it's not being continuous and expeditious, and then it stops and conducts a man overboard drill, because also stopping to conduct a man overboard drill is not consistent with the right of innocent passage. So in taking these activities, the idea is that the US is communicating that there is no requirement to exercise a right of innocent passage when it is going around a low tide elevation that does not have its own claim to a territorial sea. So in each instance when this is being done, you need to look carefully at, well, what is the maritime zone that is being claimed here, and what kind of navigational rights are being exercised, and are they consistent with the particular zones or not. But as you can see, we start from this very technical point about, well, what is a baseline? What are the different maritime zones that can be projected? But then the different interplay of rights and duties between states can become a little contested. But I'll finish there, but I'm happy to follow up on any other points when we get to the question time, but otherwise hand over to Jay.
Yeah, okay. Sige. Sige, I'll just talk muna while you're setting up the slides. Two things. First is, well, I'm supposed to talk about Philippine practice basically on baselines, the territorial sea, and associated navigational regimes. First on baselines, you already had the preview earlier. You saw the history of the various maritime claims of the Philippines, and as I mentioned, based on the original position taken by the Philippines in the 1950s, asserting the Treaty of Paris limits, the international treaty limits, as the boundary of the territorial sea, that implies that we were not actually using baselines originally. We were referring to an arbitrarily drawn box as the territorial sea boundary, not based on baselines. Okay? However, as also mentioned, that was not acceptable to the international community because everyone else measured territorial seas from baselines. So our response was to enact our 83046, which drew baselines around the country. And this was based on, could only be based at the time only on the concept of straight baselines. Okay? But number one, as I mentioned, technically it did not close the polygon because of those errors. And number two, it was not also acceptable because it basically still maintained an arbitrary limit of the territorial sea. No, yung box was the outer limit. And when it came to describing inter-island waters inside the baselines, the international community at the time did not yet accept that an archipelagic state could lay sovereignty over inter-island waters beyond a certain limit. So that was the problem that we were faced with. But we pushed and we pushed, as mentioned by Senator Tolentino, and it kept getting rejected. We were, however, able to forge a compromise, which is now what appears in UNCLOS. Sige, next slide. First of all, this is what it would have looked like. No? This is what we were pushing, essentially, for a long time, but which was not acceptable to the international community. An arbitrary box, and very little difference between the waters inside them. And everything inside the yellow line, the baselines, would be internal waters. Everything outside the yellow line up to the red line would be territorial sea. But we had the problem that we also enacted an EEZ during that time. So it was not going to be consistent with this. Sige. Next slide. The problem is most people assume that that box is acceptable and that's what we should fight for. The problem, however, is that it's not acceptable. It's been rejected repeatedly. And instead, the international community's position without recognition of an archipelagic state or archipelagic waters would be like this. This would be the threshold nautical mile limit around each and every island of the archipelago. And as you see, even inside the Visayas, there would be high seas, as I said earlier. And the Sulu Sea would be completely open to all. Okay? So that definitely would be contrary to the Philippines' national interest if we continued to push for an unrecognizable international treaty limit. Okay? So next slide. Instead, what we got was this compromise where inter-island waters are recognized to be subject to our sovereignty, and in addition, that up to 12 nautical miles from the baselines enclosing those waters are also subject to sovereignty. Okay? And then beyond that, up to 200 nautical miles, resource rights to the EEZ and continental shelf. The continental shelf being coinciding with the 200-mile EEZ, but given certain circumstances, you can extend it even beyond it, by implementing certain provisions of UNCLOS. That's why we succeeded with claiming the Benham rice, which was renamed into Philippine rice, and which now have been renamed again into Talampas ng Pilipinas on the eastern side. While on the west, you have a pending additional claim for an extended shelf area in the South China Sea side. Okay? If that is recognized eventually, that would also become part of the West Philippine Sea, part of the collective name. And you see that it's much larger. The area covered is definitely much larger than the area covered by the TOP and the International Treaty Limits claim. And the advantage is that it is recognized. Okay? It is recognized. That's why, for example, we have had since 2016 so many new agreements with other partners, not just the US, but also Australia, Japan, France, recently, Germany, and some other nations, all of them helping us build up our capabilities to monitor, surveil, and even defend our rights in the West Philippine Sea, as well as the rest of the waters of the Philippines. So that's the advantage, clear advantage of that international recognition and abiding by UNCLOS. So in terms of our baseline practice, you could say that we've already harmonized our baselines with what is provided for in UNCLOS. Again, next slide. Now we come to navigational rights and freedoms. And again, there's a history lesson embedded here because we were fighting for certain positions, but because it's an international negotiation, eventually it was subject to compromise. Originally, we had a restrictive regime, but now it's fully in accord with UNCLOS. Okay, so the problem is that, as I mentioned, all our waters have always been subject to international passage. And this is a slide from a presentation actually that I made for the IMO when we secured the designation of the Tupataha Reef as a particularly sensitive sea area. This is based on data from 2004. Okay? So 2004, that's how intensively the routes through our archipelago were used during that just 1 year. Okay? So it gives you, and actually the original data set, you could even divide this into cargo vessels, different oil tankers and other types of cargo vessels, etc. Okay? So the challenge there definitely is how do you address all this international passage, no? The passage of vessels by many nations through our waters. As Dr. Klein mentioned, UNCLOS actually allows us to regulate the passage of these vessels. And if they do anything other than merely passing through, we do have rights to respond. Okay? Sige, next slide. Now, the history of our position there also is discussed here. First of all, we have certain statements on record in the UN. No? The 56 Note Verbal, where we expressed originally a restrictive view of the right of innocent passage, and the 1972 Statement of Archaeologic State Principles, with which we went into the UNCLOS negotiations, together with some archipelagic states. At the time, there were only 5 in our group. Today, there are 20 archipelagic states in the world. Okay? And then when it came to straight practice, no, originally we did not put this down in writing, no? But at least in the 1958, with respect to the 1958 Geneva Convention on the Territorial Sea, which recognized and codified the right of innocent passage of all states through the territorial sea, we did not sign on to that. Why? Because we were pushing the archipelagic doctrine, and it was rejected. So we did not. We also rejected the proposed convention. So we are not a party to that. However, as you'll see later, the note verbals actually indicate the position of the Philippines with respect to innocent passage. Okay? And since that time, passage has been subject to some discriminatory regulation, challenge, and intervention only in exceptional circumstances. Okay? But on the whole, we have basically allowed innocent passage through our waters. Okay. Next slide. First, when you look at the 56 Note Verbal to the UN Secretary General, this is where we laid the claim to the archipelagic waters, to the archipelagic doctrine, all the way up to the Treaty Paris limits. And one thing you'll notice is that we considered all of those waters inside the box as necessary appurtenances of the land territory, forming an integral part of the national or inland waters. Okay, that's the first paragraph. Next slide. And then we mentioned that there are also maritime territorial waters, but we did not clearly identify how different this was from the inland or internal waters. But when we mentioned maritime territorial waters, we were limiting it in a way by enumerating the functions. No? Maritime territorial waters of the Philippines for the purposes of protection of fishing rights, conservation of fishery resources, enforcement of revenue, anti-smuggling laws, defense and security, and such other interests as it may deem vital to its national welfare and security. Okay? So it's also a bit vague, because if you are asserting absolute sovereignty, you wouldn't need to mention any of these little specific functions. However, when you go further, even though we were making this claim, we mentioned this is without prejudice to the exercise by friendly foreign vessels of the right of innocent passage. So even during that time, we did recognize the right of innocent passage in favor of foreign vessels. The question that was raised was the qualification that it should be friendly. Okay? Possible reasons for this, well, during this time, the Cold War was heating up, and there's still a lot of angst. This is 1950s, so there's still a lot of angst about the Second World War, and possibly unfriendly foreign vessels passing through the waters. Okay? But it was never really expressly explained what that meant in practice. Okay? Next slide. Now, even though we made the claim to the continental shelf, which, as I mentioned earlier, still was based on the 200-meter ice bath and depth of exploitability, we reiterated the recognition of the right of innocent passage of ships of friendly foreign states over the waters. So, at its base, the right of innocent passage has always been recognized by the Philippine state through its waters, at its base. No? It's just that when it came to qualifications, friendly or unfriendly, that's where you can have some argument. Okay? Next slide. Now, in 1972, when we entered into the third conference on the law of the sea and attempted this time to do better, because in the previous two conferences, we went in with our own position, didn't have anyone with us, we just tried to do it on our own. It was roundly rejected twice. So this time we got a little bit wiser. We decided to organize the group of states which would collectively push for the position of archipelagic states. 5 states joined that, no? Indonesia among them. The others are Fiji, Bahamas, and I think Mauritius. Okay? We invited them all here. They came in 1972 to Manila. And according to then Solgen Mendoza, they put all of them on board the vessel of the Coast and Geodetic Survey, what's now the Maria, put them on the vessel, sailed into the middle of Manila Bay, and told everybody, announced there that we will not go back to Manila unless we come to an agreement. Anecdote. But as a result of that meeting, they came up with a one-page agreement on the Statement of Archipelagic Principles. The statement contains only 3 paragraphs. First 2 expressing basically the principle of the archipelagic state, and the second expressing the right to draw these baselines. And the third one basically addressing innocent passage. And here again, it starts with saying that innocent passage of foreign vessels through the waters of the Philippine of the archipelagic state shall be allowed in accordance with national legislation, having regard to existing rules of international law. Such passage shall be through sea lanes as may be designated for that purpose by the archipelagic states. So here, what you have is a Trentor's restriction, no? But made only in 1972. Part and parcel of the advocacy for recognition of archipelagic waters and sovereignty over that archipelagic waters, as well as the concept of the archipelagic state. As a result of the process, of course, we got some, we didn't get others. Okay? Innocent passage was, however, plainly recognized here. Okay? But we wanted to try to regulate innocent passage through only certain sea lanes. Okay? Sige, next slide. Now, in that time, in the years that followed, UNCLOS came into force. Okay? That recognized innocent passage through archipelagic waters, but also established the right of archipelagic sea lane passage, which is slightly different from innocent passage. We can discuss that later when we get into that part of the symposium. In the meantime, we have some legislation which could impact innocent passage. RA 8550, as amended by RA 10654, this is the Fisheries Code. It describes the crime of poaching by foreign fishing vessels, and it establishes a prima facie presumption that if you're a foreign vessel in Philippine waters, which includes the EEZ, you will be presumed to be engaged in the crime of poaching. Okay, so on the surface, that might be problematic, okay, because if you're going to now interfere with every fishing vessel that enters the 200-mile boundary of the EEZ, you could be interfering with freedom of navigation. If they happen to be inside territorial waters, you could be interfering with their navigation, innocent passage through our waters. However, keep in mind that when it comes to fishing, UNCLOS allows you to regulate, to enact legislation to regulate the movement of fishing vessels. So this one is still valid. It only establishes a ground, a reason for you to take steps to make sure that they're not fishing. Okay? So okay lang yan. In RA 6969, you have the Toxic Nuclear and Hazardous Waste Control Act. Here, what it says is that we prohibit the entry and transit of banned substances through Philippine territorial limits. But since all our limits are maritime, they're all, especially in the waters, you have those limits, the question might be raised, are we therefore restricting passage? No? The practice actually is no. Why? Because the implementation of RA 6969 is with respect to importation. It does not require the Philippine Navy or Coast Guard to go to each and every vessel that enters Philippine territorial waters to check whether they have toxic, nuclear, or hazardous waste. So in practice, it has not been the basis for interference with innocent passage. Okay? Next slide. One practice that we look at is the establishment of the Trilateral Cooperation Agreement in 2016, where we, in that area down south, where a lot of incidents of piracy, sea robbery, and kidnapping for ransom became rampant, especially 1990s, early 2000s, we had an agreement with Malaysia, Indonesia, to cooperate in anti-piracy activities. And so we identified a maritime area of common concern. This is where a lot of the crimes apparently were taking place. And we designated what were called transit corridors for shipping. No? Basically we're telling ships to pass through these corridors so that it would facilitate the ability of the 3 states to surveil, monitor activities, and take action if necessary. Since then, this agreement has been seen as one of the success stories of cooperation in the region. So, next slide. Okay. Now, we were able, this allows us to conduct maritime patrols in a coordinated manner. Even if merchant traffic is required to use designated transit corridors, that's allowed, because these are basically sea lanes and traffic separation schemes, which coastal states are allowed to establish in their territorial sea. It's just that the purpose here is for security of the traffic. Okay? And then the agreement also contains various other provisions for immediate assistance, focal points for communications, and sharing of information. Okay? So this is why it has been seen as largely successful in eliminating piracy and sea robbery in the maritime area of common concern. Okay? The only problem with that is that it seems to push the activities further out, no? Which now continues to be a problem. No, but it's now in the waters outside that area. Okay? Next slide. Okay. Oh, wait, here, as you see here, the corridors are inside our archipelagic waters, no? And territorial sea, at least on our side. Yeah. Okay, so that's why it's allowable. Okay. Next slide. Yeah, okay. Other recent legislation is the Maritime Zones Act, which establishes the maritime zones in accordance with UNCLOS. And there you put, that includes, of course, territorial sea, archipelagic waters. And the Archipelagic Sea Lane Act, which was enacted on the same day, further details our policy now with respect to innocent passage. It's recognized still in archipelagic waters and territorial sea. And it also recognizes archipelagic sea lane passage in accordance with UNCLOS. It can be exercised in our waters. No? The Act further identifies 3 routes of archipelagic sea lanes, which will now be the subject of consultation with the International Maritime Organization, as well as the International Civil Aviation Organization, by the way, and hopefully will be designated in the future. Okay? Next slide. To show you where they are, so these are the most intensively used routes through the archipelago, both international and domestic traffic. Paki-pindot. Those are the 3 routes, more or less, that were indicated in the legislation. It is not a final designation. It is still now being brought for consultation and final designation to the IMO. Okay? So we're basically still allowing traffic through under the rights of innocent passage and archipelagic sea lane passage. Okay, next slide. Thank you very much.
Garcia, did you want to start?
Yes, thank you. I'm addressing this question to either party. Is there any major significant strategic difference between Philippine and Indonesian application and interpretation of archipelagic doctrine, and does that affect us? Thank you.
Did you want to start? You start.
Sorry, medyo mahina yung mic. Differences between Indonesian and Philippines? Okay. Indonesia was the first to designate sea lanes in accordance with UNCLOS. However, it was deemed to be incomplete because they designated north and south sea lanes but no east-west. As a result of that, it was regarded as a partial designation, which effectively still allows maritime powers, everyone else, the international community, to assert archipelagic sea lane passage in all Indonesian waters that are routes for international navigation, regardless of the sea lane. Okay? Originally, this was presented as a way to limit passage of foreign vessels through Indonesian waters to only those 3 routes. In that respect, it did not do so. Okay. The Philippines, as far as I know, will not go to the IMO to get a partial designation and get the same result as Indonesia. The intention of the Philippines, as far as I know, is to make a complete designation. So in that respect, I guess there's that difference. When it comes to regulations, Indonesia has enacted some regulations for archipelagic sea lane passage, which some have argued might be going a bit further than what is allowed. But on the side of the Philippines, you have not yet enacted regulations on archipelagic sea lane passage because the designation is still pending. Okay, so that will probably come once the designation has been completed. When it comes to innocent passage, basically we recognize it. Even the Supreme Court has recognized it in Magallona versus Executive Secretary. One section of the decision deals with innocent passage, and also implicitly in Arrigo versus Swift, which is the case concerning the USS Guardian, which ran aground on Tubataha Reef. The Supreme Court recognized that foreign vessels passing through our waters exercising innocent passage are also subject to the responsibilities in case something like that happens. They're also international responsible for incidents of that navigation, as what happened in the case of the USS Guardian on Tubataha Reef. Yeah. So I guess in that respect, we have yet to see whether we will enact a policy that is either the same as Indonesia or more restrictive than Indonesia or maybe more liberal than Indonesia. We don't know yet. Yeah.
Yeah, I mean, I think perhaps one point to bear in mind is that Indonesia went to the IMO also with the idea that it was going to be a complete designation, but there was so much diplomatic pushback that we ended up with the partial designation instead. And there have been commentators already making comments about, well, why is there not this particular passage or sea lane being recognized or another sea lane to the south being recognized? So whether there will be something comparable at the IMO, I guess, remains to be seen. It's just important to bear in mind as well that even if there's a designation of archipelagic sea lanes, that doesn't prevent passage through the remainder of the archipelagic waters. It's just innocent passage is required, which in the end of the day is going to have more significance for the movement of warships than it does for commercial vessels. Yeah. So, Mr. Gagiola?
Again, this is to be addressed to Jay. I noticed that with regard to Sabah, we have not designated any territorial seas, baselines, and so on. Could you talk about that one?
Well, there has been no action on the part of the government to do any of that, so I can't indicate anything either. Okay. After all, government is still bound by an MO, a memorandum order issued back in the 2000s that this should not really be discussed, especially in public. Yeah.
No, sorry, but if I may just press, will that not be taken as estoppel on our part for any further claims on Sabah?
I don't think so because officially we are still maintaining the claim. No? And in any case, Sabah is a territorial claim, therefore it's governed by a different set of rules. It's not UNCLOS related anymore. Whatever happens to Sabah, then the UNCLOS implications will follow. Okay. So ganon. For now, yeah, it's not there yet. No.
Thank you. Yes, question, Mr. Said.
Thank you very much. I'm Irvin Jules Saped, the Executive Director of the Philippine International Law of the Sea Academy. I have one question for Prof. Klein and one question for Prof. J. But first of all, I'd like to suggest for Prof. J if you can provide the slides for the Honorable Senator Marcoleta. He might be looking for some of the figures used there. Kidding aside, I'll move forward to my question. First, for Professor Klein, if a flag state does not give prior notice to pass through a coastal state's territorial sea, can the contiguous zone, which is, I think, a little part of the EEZ, be used to technically warn or ask the intention of flag states navigating in proximity of the coastal state's territorial sea? If yes, then what are the possible implications? If no, then why do some coastal states already advise the flag state to leave their territorial sea while that particular ship of the flag state is still conducting innocent passage? My question for Prof. J is, if sovereignty claims over the disputed high tide features in the West Philippine Sea have already been resolved, and there's a possibility that resolving such would award some claimant states to exercise sovereignty in some high tide features within Philippine EEZ and extended continental shelf once it's confirmed already, what are the possible implications? Thank you.
I can start in relation to the contiguous zone. So the contiguous zone is measured from the baselines extending up to 24 nautical miles. But what the contiguous zone is important for is really policing powers, and it's looking to prevent and punish particular crimes related to fiscal, immigration, sanitary, customs matters. So in many respects, it's just not relevant for a warship, which I think you possibly had in mind with your question. So all it would enable is a coastal state authority to potentially exercise policing powers over a foreign flagged vessel to potentially arrest that ship if it's, if you could imagine that there's a suspicion that there are illegal migrants on the ship and they're heading towards, or perhaps there is drugs on the ship and they're coming towards the territorial sea. So it enables a state to be able to prevent and punish crimes that are happening in a band of water adjacent to the territorial sea. But those policing powers can't be exercised over a warship because of its sovereign immunity. So it's kind of a different situation, I think, to the idea of sort of prior notice and asking it to leave. Certainly, if a warship is coming through the territorial sea and a coastal state has a requirement of prior notice, and there is a failure by that warship to give prior notice, but it is otherwise sailing through, in my view, that ship is entitled to sail through an exercise of its right of innocent passage. If that is all that it is doing, if its only failing is to give prior notice, then that's not great diplomatically, but it's still legal. So if there were other activities that happen, but again, I would be looking at what the warship is actually doing to be able to ask it to leave on the basis that it was non-innocent passage.
On the second question, the islands and high tide elevations in the West Philippine Sea as well as in the high seas beyond the West Philippine Sea, in that area, sovereignty over those islands and high tide elevations was not resolved. Okay, so it's still contested technically. Although for us, it's not contested for us; it is ours. Okay, but other countries are contesting it, bale. Okay. If in the future it is eventually settled and negotiated, and what happens is, again, a compromise where you have a give and take, and some islands eventually are agreed upon to be under the sovereignty of other states, no? What happens is, because of the 2016 arbitration, basically what is affected is only the sovereignty over the island and the territorial sea around it. The waters around it will not be affected because they have already been determined to be not entitled to either EEZ or continental shelf. And I would expect that the Philippines would certainly take that position as well going into that negotiation. So it would not really change the configuration of the maritime zones, especially our 200-mile EEZ continental shelf. No? It will have those holes, shall we say, no? Because of the islands and rocks, but then that's already the current situation. No? Insofar as the EEZ and continental shelf is concerned, which is the far greater area where you will find more of the resources, maybe most of the resources, that is already settled. If it's within 200 miles, they all pertain to the Philippines. If it's beyond 200 miles, it is subject to, it is part of the international commons where all states have the same rights as any other state, including the Philippines. It's only the islands and their enclaves of territorial seas which are not settled. Yeah. And if eventually it's settled and then it's distributed, well, that's how it is. No? I mean, if the countries agree to it, that's it. Yeah.
Were there any other questions? Maybe if somebody waves, because I can't see the board. Otherwise, there we go. Ms. Salvio, please.
Thank you. I am from Xavier University School of Law po. It's been a while since I studied Consti, so I just wanted to ask, with the Supreme Court decision in Magallona and the subsequent ones relating to the baseline, have we effectively defined our definition in the Article 1 of our definition of territory relating to the waters in and around the Philippines as internal waters? Have we effectively dropped the internal part and adopted the archipelagic sea definition? That's the part that I would like to be clarified on. Thank you.
Yeah, thank you. This was discussed at length during the Senate deliberations on RA 12064, what became 12064. And the point made was that, number one, as pointed out in Magallona, whether you call it internal waters or archipelagic waters, what matters is that we have sovereignty over them. The designation of internal and archipelagic admittedly differs in domestic law and international law, but it's the exercise of rights which is more important. And in that case, we have not dropped our claim to sovereignty over these areas. No? When you think about it, the definition, the waters around, between, and connecting the islands of the archipelago itself is actually rather big, because the EEZ is all around the archipelago. They all also are around the islands of the archipelago. So you could interpret it that way as well. So it's not a sufficient definition. What 12064 provides is now the opportunity to harmonize our domestic legislation with UNCLOS, no? without necessarily doing violence to the constitutional definition. As I said, no? Even though it's internal waters or archipelagic waters, what matters is that we still continue to assert sovereignty over those areas. Some have raised the argument that internal waters are not subject to passage rights by foreign vessels. That is correct, no? However, this also, overlooks the other provisions in international law, in that one very often overlooked provision is in the territorial sea part, when a state enacts strait baselines to enclose waters that used to be subject to passage rights by foreign flag vessels, no? Those rights remain. They are not erased by its enclosure in the baselines. So even if we did that, no, those rights of passage which have existed through these waters, as I pointed out, since ancient times, hundreds of years, that would not be affected. No? And when you look at the international law in internal waters is not clearly defined in UNCLOS. So it's the prior practice and prior documents which indicate what is meant by internal waters. When you find the document which explains that foreign vessels do not have rights of instant passage through internal waters, it is qualified. It is qualified by saying that unless by usage, customer usage or treaty, it is allowed. No? So it is possible actually for passage rights to exist in internal waters if there is prior agreement and prior practice. So that would fall, the situation would still fall under that exception, no? And in the doctrine of internal waters anyway. So in a way, it's still, it's still, it can still be raised, of course, no? Given, how we are so litigious and given the wordings, but I believe that it is harmonizable. Otherwise, we will be in a situation where we will be acting contrary to UNCLOS, in which case some other countries will then benefit from that. Yeah.
Sorry, Professor, I may just follow up. If memory serves, actually made a reservation when we signed UCLOS, saying that we have our definition of internal waters. So have we also drawn that reservation?
I would say yes, because number one, when we ratified UNCLOS, we put in the statement of understanding where we reiterated treaty lines, etc., etc. That was objected to by many countries, including Belarusia, Australia, and several. I mean, when you look at the record of ratification, we were able to get the most number of objections to our statement of understanding. And so in response to the latest one in 1988, which was by Australia, we then filed a declaration, no, that we will be harmonizing our domestic legislation with UNCLOS. So that's the 1988 statement. And so that's why it took us a long while, but the series of legislation indicates that we have implemented that commitment to harmonize the legislation. And so we're no longer insisting those positions originally made. Yeah. Besides, the practice evidences that we have not been insisting on that. No? The South China Sea arbitration, when we went in there, as Justice Carpio pointed out, we had to go in with clean hands. So all of the contrary interpretations and positions, we had to forego that in order for us to be able to show to the court that we are fully implementing UNCLOS and that we are abiding by UNCLOS in order to be able to avail of all the rights. No? And then since the time we've had yung implementation of UNCLOS through the ECS claims and then the Maritime Zone Act and Archipelagic Sea Lanes Act. So there shouldn't be any more question that we are now fully invested in and implementing UNCLOS as it is.
Is there any other question? I think there are no questions from our participants.
Sorry, there's one more.
I see. There's another one, ma'am.
Good morning. I'm from the University of the Philippines in the Visayas. Since Article 19 of the UNCLOS refers only to foreign ships, I assume it's manned. It has a crew. What is the treatment of unmanned water vehicles or even aerial drones? How are they treated under the UNCLOS? Especially since it would only mention launching or taking on board of a military craft. How about flying the same? Thank you.
If you're talking about launching a drone during innocent passage, then that would be a violation of the right of innocent passage. If a vessel is outside the territorial sea, but then you're talking about uncrewed vessels coming through. So there are many issues around this. In relation to aerial drones, then the question, it's the sovereignty of the coastal state. There is no right of innocent passage that obtains to the airspace, so any drone that was being launched by another country is potentially violating the airspace of a coastal state if it is flying over the territorial sea. And then also rules of civil aviation start being relevant in that regard too. Then once you start talking about uncrewed vessels, and I was going to mention them in the session this afternoon, one of the first questions you have is whether they even count as ships or not, because it's ships that have a right of innocent passage. So we've been having a debate about whether maritime autonomous vehicles count as ships or not. In terms of the underwater ones, the rules are a little bit clearer in as much that Article 20 refers to submarines and other underwater vehicles. So even if something is not technically a ship, it's still an underwater vehicle, in which case under Article 20 there is a requirement that it surface and it shows its flag. If it is technically unable to do that, then I would say that it is technically and legally not allowed within the territorial sea. So there's still, there is not a requirement in terms of innocent passage that a vessel have a crew on board. So technically, if something is a ship, and you see the maritime autonomous surface ships that have been trialled for moving cargo, and so they look like a ship, they're probably a ship. They are allowed through, but then we have questions around coastal state regulation of, shipping requirements, construction and equipment and design. And mostly that's going to have to be regulated by the standards set out by the IMO, but it doesn't negate a right of innocent passage in itself. But there's a lot of work going on at the IMO in relation to maritime autonomous surface ships that will be relevant for the commercial vessels in this zone, and I think will have implications for navigational safety and what regulation coastal states can have. Yes, follow up?
No, it's a different question if it's okay. Because you did mention in your talk that because we measure the baselines according to the lowest point, correct? And I think you did allude to the fact that there are some island states that are losing their territory, which means the Philippines will not be immune to that, of course. I'm just thinking, like, how will international law, UNCLOS, or customary international treat such loss of territory with respect to our maritime claims? And should countries like the Philippines start thinking about developing treaties or whatever binding agreement there could be to protect our interests, given that we are going to lose territory through rising sea levels?
Yes, so international law has been dealing with the question of sea level rise, and I would largely defer to Professor Schofield for his enormous body of work on this issue. But so just to respond briefly, and you'll probably follow up later, but at the moment, countries are moving much more towards a position where they're allowing for the possibility that states can fix their baselines. There had been a debate going on for some time about whether baselines were ambulatory and they needed to be redrawn when a coastline shifted. But following the work of the International Law Commission and the responses of states that have gone into that particular study, more states are moving towards the idea of fixing their baselines. And equally, the practice that we've been seeing through the Pacific Island states, similarly looking to enshrine their baselines in legislation through bilateral and other multilateral treaties. And in the International Court of Justice's advisory opinion on climate change, which looked at Article 16 of UNCLOS, which talks about the requirements to publish charts, the ICJ said in that context that once a state has, published its chart and advised of its baselines, there is no requirement in UNCLOS to then update it or change it after that. It didn't go into all the details and all the questions, but even getting that interpretation of Article 16 kind of supported the idea that they can be fixed and then they can be stayed. So certainly I think for the Philippines it's advisable to be clear on what those baselines are, and once they are published, they are published. And equally, if it means concluding maritime boundary treaties, then that is being seen as another way to sort of fix the baselines in the maritime zones as they are now, irrespective of sea level rise. Clive, did you want to add into that?
If we have time for a minute or two, then yes, thank you very much indeed, Professor Klein. It is a really pertinent question for all coastal states, not just the small island states of the small island developing states of the Pacific Islands. Substantial amount of the narrative has been driven from that part of the world and the threat that these low elevation island states particularly feel against the threat of sea level rise. But the traditional, I absolutely agree with everything that Professor Klein has indicated, the traditional interpretation of normal baselines consistent with Article 5 of the Convention has been that they are indeed ambulatory. As the coastline, you get deposition or erosion on the coastline, therefore the low water line will move, your normal baseline will move, and therefore the outer limits of your claims to maritime jurisdiction are also potentially susceptible to change. That was the decision or the conclusion reached by the International Law Association, ILA, Committee on Baselines as recently as 2008. Now, the ILA Committee on International Law and Sea Level Rise, which I was part of, reached a different conclusion. That indeed, if baselines are properly established under the Convention and declared to the UN Secretary General through the Division of Ocean Affairs and Law of the Sea, then they should be capable of being fixed. The International Law Commission study group on the same issue engaged with over 100 states through the 6th Committee of the UN General Assembly, and not a single state said no, which is quite a powerful statement. Some are less enthusiastic than others, I think it's fair to say that, but the fact that, as Professor Klein indicated, that the International Court of Justice, in its advisory opinion, came down with the same conclusion, that once baselines, limits, and boundaries are declared, there is no need to update the coordinates associated with them. And that's a powerful validation of the practice of the Pacific Island states. But again, they're not the only coastal states under threat. This is very much a global issue, and every coastal state, including the Philippines and Australia, needs to pay rather more attention to trying to establish and fix their baselines and therefore the limits of their maritime zones also. Thank you.
Thank you, professors. Sir Jay, have we published po ba our, so I'm so ignorant, have we published our baselines naman? Okay, then I guess that's it. Thank you.
RA 9522. Yeah. Although some people naghahanap pa ng mapa.
Sorry, question down the end.
Yeah.
Hello. Thank you very much, Professor Klein and Professor Butambakal, for the presentations a while ago. Just a question, either Professor Klein or Professor Butambakal can be an answer. In light of persistent actions by China that appear to disregard the UNCLOS of the sea framework, particularly through expansive baselines, claims, and restrictive practices in areas that should fall under territorial sea regimes. How should coastal states like the Philippines respond? Should they strictly adhere to UNCLOS baselines and navigational regimes to preserve legal consistency, or consider calibrated countermeasures that risk reshaping customary norms but may better protect maritime entitlements in practice? Thank you.
Wow, that's a complicated question. In terms of the law, of course, the position should be to preserve the law. After all, it was the result of long negotiations to which the other party, I assume you're referring to the same party, also signed on to and ratified. Okay, so what's happening now is, I think, creative reinterpretation sometimes, or attempts to take advantage of some of the areas which the law did not yet clearly settle as a way of expanding their claimed rights and entitlements. No? I think that insofar as those are concerned, if there is that room for interpretation, no, then the Philippines should take the position, the interpretation that favors its interests. And I think by and large, our interpretations should be aligned with law as it exists today. So we would insist on compliance with the UNCLOS, compliance with the rulings in the South China Sea Arbitration Award, etc. And that way, it would be clear that excesses or inconsistent actions that are inconsistent with what is laid out there would be contrary to law. And for a country like ours, I think it's important for us to be able to hang on to that, no? And at the same time work for an international community that works on the basis of the rule of law. Because if we were to simply give it up and accept that power is what will prevail, and therefore we will recalibrate based on power rather than based on law, we might run out of room to maneuver soon. No? Because that's based now on totally different considerations and sometimes probably totally limited considerations on our part. So that's why we need to be able to continue to assert and maintain law as it currently stands, I think. No? Recalibrations in policy, no? As long as they're within the bounds, the parameters that are described by law, they're okay because that's allowable. As long as we do not change the law itself, then we're fully entitled to that room for maneuverability within the bounds of the law, I think.
Okay, thank you so much, Attorney J. Batong Bakal and Professor Natalie Klein. Our conversations will continue after lunch. We kindly ask everyone to be back in this time by 1:20 as we will promptly resume the afternoon session. Once again, thank you for your active participation. Let's give them a big round of applause, please. Enjoy your lunch and we look forward to seeing you back here shortly. Thank you.